Number 41, People versus John Daly. Counsel, would you like any rebuttal time?
Yes, please. 2 minutes, Your Honor.
2 minutes. Go ahead.
Thank you very much, Your Honor.
Sure.
Judges, if I may, I am counsel for the appellant John Daly. I've been at this case for 7 years. My client has been incarcerated for 9 years. I do want to thank Judge Grafeo for granting leave in this case. If I may, I'd like to try and cut to the chase, or what I believe is the chase in this case, and that is whether there is spillover effect on the evidence that has already resulted in a new trial as ordered by the Appellate Division, 2nd Department. There was, without question, a serious Rosario and Brady violation here. But I just want to briefly go back to tell the Court of the history of what happened in this case and how the people apparently seem to be denying what has transpired here. Your Honors know that my client was originally sentenced to 35 years. That was reduced by the Appellate Division to 25 years. Leave to appeal in the Court of Appeals the first time around was denied. Thereafter, my client filed a FOIL request with the Police Department and Nassau County. That was denied. The appellate process within that administrative proceeding was also resulted in a denial of his request for FOIL information about prior statements or any other evidence that might have a bearing on his conviction. Thereafter, we brought an Article 78 proceeding. Now, you would think during this process the people would be looking through their files to see if there were any additional statements that might have a bearing.
I mean, I think I understand the point you're making. What does that have to do with spillover?
It has everything to do with spillover, Judge, because the people now in their briefs in chief here have argued once again that the Rosario and Brady material did not have an effect on the remaining counts.
Those materials did relate entirely to the OTB event, didn't they?
No, Judge, I would not say so. And the reason for that is as follows. Your Honors know, having read the briefs, that the Rosario issue pertained to Peter Shank. He did testify at the trial. The Brady material had to do with something like 11 other statements.
But none of those, neither Shank nor any of the other 11 were at the gas station. They were all in the OTB, right?
Well, that's correct, Judge. But the test here, as set forth by this Court in 1994 in People v. Kermeny, is whether that evidence on those tainted counts had a reasonable possibility of affecting in some meaningful way, and that's language used by Judge Seperik in a subsequent case in 1999. So the test is twofold. Basically, whether there's a reasonable possibility that that tainted evidence had a bearing on
So why did it?
Okay, thank you. And the meaningful way part of it is what is really, really critical here. Now, that has not been defined, as Judge Grafeo noted during our telephone conference on the leave application here. That really hasn't been defined by this Court. And we're arguing that there was a meaningful
Wasn't the evidence much stronger in the Mobile case?
Judge, I would say, well, it was much stronger. There's no doubt about that. However,
You had 4 witnesses who testified, and there was a ballistics report on the gun.
all right, but
So
also,
that's quite separate and distinct from the Brady and Rosario issue. So
but let me just show you what I think.
I guess what we're asking is, how does the meaningful fall in with that type of independent evidence?
Okay. Let me try and do that in two ways. One is, I believe that the testimony was that the assailant was wearing a mask, and there was some dispute about how much of the assailant's face could be seen by those witnesses at the Mobile gas station.
They recognized him, though. Didn't
sorry,
they
Judge?
recognize him?
I'm sorry?
Didn't they recognize him?
They testified that they did recognize him because there was a hole in the mask. This was a mask that covered the entire face.
They recognized him because he had been there before using his credit card and asking gas customers for the cash.
Well,
Right.
that's what they said, Judge. But there was also testimony and an indication that there were at least 2 other witnesses who could not identify the assailant. There was also testimony indicating that one of the Bajrais, if I'm pronouncing that correctly, there were 2, junior and senior, was not even at the scene at the time. But I want to show you something that I think is very, very important on this issue. And this is from our appendix at page 318. Now, this is where we got into a whole dispute about the theories that were utilized by the defense during the trial. It has been affirmed by Mr. Peace, who was the trial lawyer in this case, that there were 2 theories, not one. The first theory was a misidentification theory. That had to do with the OTB part of the case. And the second part of his claim was that it was someone by the name of Rooney, who appears in this photograph, behind Mr. Daly, who actually did the mobile gas station part of the case. Now, if you have a misidentification issue, the last thing you do is support it by showing that your client looks exactly like the purported assailant. Here's what I think the court needs to look at. How did those 12 statements have a bearing on the defense theory? If we're trying to go back now...
You're saying that if he'd had those 12 statements, he might have chosen another route, he might not have tried the exchange of identification theories?
That's exactly right. And that is hitting the nail on the head, I think. He could have used, Judge, he could have still used what I call the Looney-Rooney defense as an alternative theory. He could have said, you know, like Perry Mason, if you're really looking for a culprit here, here's a possible culprit. He had a prior conviction. He was on parole. He had a gun charge that he had been convicted of. That's an alternative theory. The main theory would have been, Judge, still misidentification.
The misidentification awful tough on the gas station when the police see him drive up in the white car 20 minutes after the event, and they later find the gun in his house. I mean, who was he going to pin it on except Rooney?
Now, wait a minute. 2 parts to that question. Let's take the car first. It was a white car. Was it the same car? There's some question about that.
Weren't those
There was a
questions resolved by the
concession.
jury?
I'm sorry, Judge Jones?
Weren't all of those questions resolved by the jury, more or less?
No, they weren't. And here's why. The second part of Judge Smith's question has to do with the gun. Let's take the gun for a second. The Bajrai said it was a long-barreled gun. A long-barreled gun that was recovered from Mr. Daly was 10.9 inches. A .38 caliber gun.
But the ballistics expert said it was the one that put the bullet in the man at the gas station.
No, there were 2 reports. The first report on the OTB part of the case said that the bullet was just inconclusive.
Right, but I understand. The OTB, the ballistics on the OTB was inconclusive. The ballistics on the gas station linked it to a gun that was in your client's house. If you don't have the Rooney defense, what do you got?
Well, we have attached to our papers a report from a ballistics expert on our side, which was never used by Mr. Peace, Detective Ganallo. Now, that could have been offered to show that the people did not conduct all the tests that were required.
Okay, so
and
you
that
say
the bullet
and
at
what
mobile didn't match up.
about the jacket and mask that were found in the house?
Okay, good question. Thank you. I'm not sure I answered yours yet.
Take your time.
Look at the jacket and mask. First of all, there was no paraffin testing done. This is very important. And there was really no definitive testing done on the mask or any of the clothing that was recovered from John Daly's home. So you have a dispute about the size of the weapon. They argue now that the description given, a long-barreled gun, by the witnesses, all the witnesses said a long-barreled gun. That's 10.9 inches. A .38 caliber was recovered from John Daly, okay, or his home, I should say. That doesn't match up. But there's no paraffin testing. You know what paraffin testing is? Burns on clothing and so on that would indicate a recent firing of a weapon. There was no paraffin testing done on the clothing, no paraffin testing done on John Daly at all. So that's how you address the gun issue. The gun issue, I believe, is still in dispute. usually in dispute, but it could have been brought to the fore by Mr. Peace, instead of Mr. Peace conceding in his opening statement. I mean, this is just absolutely wild. He concedes in his opening statement that the gun belonged to John Daly. That's not it. First of all, you didn't even have it on the first OTB case, and I argue you don't have it on the mobile case.
You're not asking us to find ineffective assistance, are you?
I'm sorry?
You're not arguing ineffective assistance here, as I understand. You're arguing spillover on the Rosario Brady violation.
What I'm saying, Judge, is this, with all due respect. I had indicated earlier in my first round of appeals that Mr. Peace was totally ineffective. Under the Strickland standard, under the Baldy standard of this Court, ineffective, okay? The appellate division disagreed with me. Now, what we're trying to do here is we're splitting hairs over whether this evidence, these 12 statements, would have made a difference in a meaningful way, as Judge Siparik said. And I'm arguing, Your Honor, that the failure to disclose these statements exacerbated the ineffective assistance issue.
You're saying, your argument essentially is that the materials could have affected the defense strategy and led it to a more effective strategy. Do you also argue that it might have directly affected the verdict, or is your argument limited to the defense strategy?
No, it's not limited to defense strategy, and I thank you again for the question. It also includes the verdict, Your Honor, and I say that for a number of reasons. Number one, there was a 440 motion that had been made which was denied, and leave was denied by the appellate division on that. But we conducted a survey of jurors. Even without the 12 new statements before them, they said that Mr. Peace was ineffective. So with this new information, I would respectfully argue that the people just added to that problem. They added to the problem of his ineffectiveness. And now their brief is replete with references to how effective Mr. Peace was.
What would you have done? Suppose you had been trying the case and you had the 12 documents that you should have had. How would you have used them to get an acquittal in the gas station?
Okay. Well, first of all, you need to have one question before that, if you don't mind me saying so, Your Honor. And that is, Mr. Peace did not ask for a severance. So in our brief, we gave you two scenarios in response to that question. One is with the severance, one without the severance. Which one do you want me to answer? Both?
Now, try it without the severance.
Without the severance. Okay, without the severance, we've got the 12 statements. We've got Mr. Shank caught in an inconsistent statement. And just to show you the difference in his two statements, if you just look at...
Okay. Assume you destroy Shank's credibility utterly. What does that do for the gas station?
On the gas station, it's the same thing, Judge. That's where the spillover comes in. If you have impeachment on Shank, and then you have impeachment also, or at least reasonable doubt, that's the job of the defense. The job of the defense is to build reasonable doubt into the case. How do you do that? Terry Rogers was never called as a witness. There was virtually nothing brought out about Kieran Ryan. Here's Kieran Ryan apprehended in Queens, presumably on a robbery charge with a prior record, matching the description of the assailant given by Peter Shank.
Counsel, you'll have your rebuttal time. Thank you. Counselor? Counselor, let me ask you a question.
Yes, Judge.
Is it possible that there's no spillover when you have cases presented together in this way? I understand the particular arguments that your adversary...
Is it possible that there's no spillover?
Yeah,
Absolutely.
that in other words, it's presented together in the way that this is, in the summation and the sort of talked about together. Is there almost inherent in that situation a spillover effect?
Oh, no, not at all, Your Honor. And this
Why
case
not?
is actually a very good case to demonstrate
Yeah,
a
go ahead.
situation where no spillover occurred. These two crimes were factually distinct. They occurred.
But I think, as I understand the Chief's question, no, I don't care how distinct they are. Isn't any juror going to be impressed by the fact that you've got two? Isn't the difference between two and one just enormous? I mean, a guy is charged with robbing, with an armed robbery with a gun. You say maybe he didn't, maybe he didn't, maybe he did it, maybe he didn't. Now they've got him for 2. Say, hey, this guy looks like a robber to me. I mean, isn't that inevitable in any case?
No, it's not inevitable in any case, and certainly not in this case, because we have the judge issuing a very clear charge that the jury is to consider each charge separately. In fact, at the end of his final instructions, the court told the jury, you must consider each count separately with the evidence.
Doesn't that put quite a strain on human nature?
No, not at all, Your Honors, because we must presume that the jury can follow the court's instructions, People versus.
Yeah, they do it a lot, and they acquit some, and they convict some, and they do reduce charges. But why did you try them together? Why did you try these 2 together?
Well, because they were properly joinable, because they charged.
Well, of course they were, but it seems to
Yes.
me you had them dead to rights on mobile, and you had some kind of a question on OTB, and it would. The spillover would work a whole lot better if the jury come back the other way. But
Well, in this case, clearly, Judge, it made sense to try these crimes together because while the civilian witnesses were completely distinct from each other, that is, no witness to the OTB crime was a witness to the mobile gas station crime, there was some police officers, some of the detectives who did offer testimony that in regard to both cases. And in terms of judicial efficiency.
Doesn't that exacerbate the problem?
Oh, no, not at all, Judge, not in
Of
this case.
spillover, I mean.
Does it no, not in this case, Your Honor. Because clearly the inquiry goes back to, is there
Well,
a
if the
reasonable
jury-
possibility?
The jury
Yes.
hears a police officer testimony.
Yes.
And attaches credibility to the testimony of that police officer and his investigation. Isn't there like a natural, well, he must have investigated both of them properly?
Well, not in this case, Your Honor, because again, it was really very distinct. We did not have a police officer saying the defendant committed the OTB crime and the defendant committed the mobile gas station crime. We didn't have that sort of testimony from the police
Didn't
officers.
the prosecutor also, though, conflated to some degree the 2 cases and talking about, in general, witnesses identifying him? In other words, in many respects, there wasn't an attempt to separate it out because, again, inherent in it being presented together. And I'm just trying to I think Judge Smith indicated, what is the jury to think in that kind of situation? Can they really separate it out in this kind of situation where there are 2 separate incidents that true, the person shot, they're both in the abdomen, but, you wouldn't acknowledge that there's any difficulty in being that the 2 cases were presented together?
Well, Your
And
Honor,
I
yes.
acknowledge, and I mean, I think it's obvious in looking and reading the record that there's much stronger evidence in the mobile case than there is in
Oh,
OTB.
certainly is, yes.
Yeah, but answer the first
But again,
part.
Your Honor, the test is reasonable possibility that there was an effect, that the verdict was affected in some meaningful way. It is not beyond any possible doubt that the jury could have been affected from the tainted count versus the non-tainted count. And applying this Court's test, reasonable possibility, there was no reasonable possibility of a spillover effect in regard to this case.
Just because the evidence is so much stronger, basically? I mean, that's the heart of your...
Well, it is not only because the evidence was stronger, and it certainly was. They have the 3 witnesses who identified the defendant, who knew him from prior very remarkable circumstances, recent circumstances. And also on that note, in terms of who identified whom, the appellant made a misstatement of the record in that he set forth that there were 2 people who could not identify the defendant in the gas station robbery, and that is just, it is not true. That is totally not a part of the record.
One of the troubling things is that was it 11 or 12 Rosario violations? It's not in the record. How did that happen? Do you know?
Well, there was an affidavit an affirmation from the prosecutor, and he set forth that in regard to the statement from Peter Shank, which did qualify as Rosario Matilda, that he had never seen that statement before. And also in the prosecutor's affirmation, he stated that in regard to 3 of the witnesses, 3 of the statements, Mr. Fleming, Mr. Simone, and Mr. Balsamo, he had determined that this did not constitute exculpatory evidence. He did not remark on any other of the statements, so
So-
we don't know why they were not turned over, if the prosecutor had even seen it. That is all speculative, and indeed
His,
it
his
was
not seeing it might be a problem in itself, don't you think?
in terms of...
It suggests that this case was not handled perfectly. I mean, isn't the prosecutor supposed to see the prior statements of the witnesses?
Well, if the prosecutor has it, certainly, and the prosecutor is supposed to reach out to the police department to procure these statements.
There was a
of course,
fairly large-scale mess up here. You got
Well,
12
there were-
documents that surely should. I mean, whether they're technically Rosario or not, if they don't mean anything, why don't you just hand them over?
Well, certainly, Your Honor, there were 12 statements that related to the OTB robbery, but however, something that came out, I believe, in the appellant's reply brief, the appellate division did not state that each statement constituted either Brady or Rosario material. That's not the case, and some of these statements really possessed no useful information to the defendant. So to say it was some really gross error that somehow caused defendant...
Okay, well, I'll withdraw gross. There was an error.
Well, there was certainly error that Mr. Shank's statement no doubt should have been turned over.
Do you take the
Because that
position on
was-
Rosario that since you weren't going to call those people, they weren't Rosario material, and therefore you didn't have to turn them over?
Well, no, the people do acknowledge that Mr. Shank's statement, the one person who did actually testify...
But the other
at trial,
11?
Statement as to, the other statements, those witnesses did not testify at trial, and therefore their statements could not and did not constitute Rosario material.
Which gets you then to Brady, and this is always troubling. The people decide that this is or is not Brady, and therefore is or is not discoverable.
Yes.
And Mr. Liotti makes the point, with respect to some of them, that there were descriptions that certainly would have helped the defense. How do we resolve things like this, where we don't know that 11 statements there's 11 statements that exist that we don't know about?
Right.
That you've made a determination, we're not going to call these witnesses, therefore they're not Rosario. And we've decided that they do not exculpate the defendant, so we're not going to give them to them. And it always seemed to me, similar to what Judge Smith just said, if they don't exculpate him, why not give them to him?
Well, Your Honors, again, I guess that is why we have the appellate process, the 440-10, but at the 440-10
No,
hearing...
you'd say you should win all of those. There is no process because they never come to the light because they're not Brady and they're not Rosario, and therefore you can keep them, right?
At least that was your office's
Oh, yes, the
argument, wasn't it?
oh, yes, absolutely, yes. The materiality argument, absolutely.
Isn't
Your Honor-
I guess to rephrase the question, isn't it a policy of questionable wisdom to go through these things and decide in close questions that you're not going to disclose them because they're not Brady? Wouldn't it be much wiser and possibly more professional to just give them to the defense lawyer whether they're Brady or not?
Well,
Unless you're worried about the
clearly-
witnesses being rubbed out or something?
Well, clearly, the prosecutor does act at his or her own peril when they decide, when they make the determination as to whether or not material should be turned over and whether or not it constitutes Brady material. That's true, Your Honor.
What's the peril?
Excuse me?
What's the peril to the DA?
Oh, that the case would be reversed on appeal?
But
That
if we never...
the things will turn up someday. If they don't turn up, he has no peril.
If the
If the things he decides not to withhold or the things he decides not to disclose are never disclosed, there's no peril.
The only peril then is
That's
to the
true,
defendant.
yes, that is true. That's right.
Doesn't
yes.
the peril then fall on the defendant?
That in terms of...
Brady material not being disclosed.
Well, ultimately, it is, it would fall upon the prosecutor should they be disclosed. However, Your Honor, yes.
The appellate division ordered a new trial in
Yes.
the OTB case.
Yes.
Has that commenced? Or are you
No, it
waiting?
has not, no.
So, and I assume if Mr. Lowry was successful here, he would be requesting there'd be a new trial on both, and he'd be requesting a severance to avoid this problem in the future.
Well, I don't know what defense counsel would request in regard to this case. I don't know. He may well request a severance, but the question is, would it be granted? I mean, certainly it's within the judge's discretion to keep both these cases together because they do involve crimes, similar crimes, that is defined by the same statutory provision, the assault, the robbery portion, attempted robbery would go with the robbery portion, and again, the witnesses in common. So it would be certainly within the judge's
So
discretion.
you're arguing that they are so similar that they should be tried again together if we were to reverse?
No, the people are arguing that pursuant to statute, these cases are properly joinable because they are defined by the same statutory provisions.
But is it wise to join them, I guess, is the question being asked.
In terms of judicial economy, yes, it would be wise,
In
again.
terms of fairness.
Well, with appropriate instructions, and again, that the court did issue appropriate instructions here, did ask the jury to consider each charge separately. So it would be appropriate, because indeed, Your Honor, if the rule were otherwise, then there would never be an incident where cases could be joinable under the statute when they charge the same crimes, and that surely can't be the case.
Okay. Anything else, Counsel?
No, Judge.
Thank you.
Thank you.
Counselor, go ahead. Rebuttal.
Yes, just briefly, Your Honor. Thank you very much.
Sure.
You can see, I think, from the remarks of my esteemed adversary that they're still hedging on the issue of Rosario and Brady. And I agree with Your Honor, this is a very perplexing problem. If I may, we know from the Supreme Court of the United States in Kiles v. Whitley that the people have an obligation under a due diligence standard to search out and find exculpatory evidence or merely Rosario material that might be exculpatory or could have a bearing on impeachment. That's Kiles v. Whitley. Supreme Court of the United States, local prosecutors don't follow the Supreme Court of the United States. They make these things up for themselves. But I'd like to just, if I may, Your Honor, quote very briefly from a case in the Appellate Division, First Department, a lesser court than this one, but an esteemed court nonetheless, from 1996 in the case of People v. Palmer. The court said, in this situation, reversal of the entire judgment is required, regardless of our evaluation of the potential impeachment value of the documents with respect to the robbery, mindful that this court's retrospective analysis of the utility of a piece of evidence should not be substituted for that of the single-minded devotion of counsel for the accused at the time of trial. And parenthetically, I would also mention a case from the Second Circuit, which we cited in our briefs below, the case of United States v. Gill, 297 F. 3rd, 93, 2002, from the Second Circuit, provides for the exact same thing. And I don't fault this court for trying to figure out what the trial strategy might have been with the 12 statements. But the reality is, none of us were there at the time. The 12 statements clearly satisfy the reasonable possibility standard and also the meaningful way standard as set forth by Judge Saparic in 1999.
Okay, Counsel.
Thank you very much.
Thank you both.